Hi, I'm Eric. Eric Wright. I'm not a cop, but I play one in cartoons. So often, in fact, that my friends call me Cop E. Wright. I'd like to take a minute of your time today to tell you about intellectual property. But more specifically, copyright. Copyright, quite literally the right to copy, is the legal permission to use or distribute an original work. By default, this right is held by the creator for a limited period of time, which is usually for the duration of that creator's life, plus 50 years. This right gives the author control of the work and any profits resulting from its use. For example, I myself am an original work, and my creator is this guy. By the very act of putting me down on this virtual paper, he owns me. Neat. He also owns the rights to this voice recording, this script, any sketches or paintings that may have contributed to this cartoon's creation, and yes, the cartoon itself. These rights will last as long as he remains alive, and then for another 50 years, or until he sells the rights to someone else. However, just because he thought of what in retrospect was a pretty obvious idea of a cop who likes to talk about copyright, doesn't mean he owns that idea. No one can legally claim ownership of an idea, only the form that idea takes. Disney doesn't own the concept of an anthropomorphic mouse. They own Mickey. Now I know what you're thinking. There's no way that guy filled out the proper paperwork to own the copyright on anything. And you're absolutely right. Of course he didn't. I mean, look at him. But the beauty of copyright is that he didn't have to. Once an idea is put into a concrete form, such as a drawing or an audio recording, then copyright applies, automatically. Copyrights may be registered with the US Copyright Office, which makes suing for copyright violation easier and more profitable. But even without registering an original creation, copyright applies anyway. It's just harder to prove. Now, copyright may be great for the copyright holder, but what about other people inspired by that person's creation? Under the conditions collectively known as fair use, other people may use a copyrighted work without the copyright holder's express permission. These conditions include education, scholarship or research, search engine results, news reporting, and parody, commentary, or criticism. These conditions allow for the progress of science and useful arts, which the copyright clause of the Constitution itself seeks to promote by giving these rights to creators in the first place. Though there has been much debate on the subject, fair use is generally considered a defense to be used in court, not a right. Any discernible use of a copyrighted work could result in a lawsuit. For this reason, most people avoid using copyrighted work whenever possible. However, if a copyrighted work is essential to your project, here's what you need to know. Using the work must either advance knowledge or show progress of the arts. It should be transformative rather than derivative. An art installation of a Mickey Mouse trap, for example, would have a better claim to fair use than, say, someone selling homemade Mickey Mouse umbrellas. In general, the less of the copyright work used, the more likely the sample will be considered fair use. Keep in mind, however, that much in the way a pop song has a hook, certain parts of the works are often more important than others. The value of the copyrighted work in the open market must not be damaged by the reproduction. So even if your movie review website's video critique of the new Mickey Mouse movie is covered, the clips of the movie you post there should not act as a market substitute for seeing the movie itself. This last is the driving factor behind the recent lawsuits academic publishers have filed against certain colleges for their method of distributing articles to their students. Fair use has long served as the backbone for the copying and distribution of articles to students, but if college students are the primary market for a given article or book, isn't the market being affected by giving the articles out for free? One final nugget for thought. Creative Commons, a nonprofit organization founded in 2001, gives creators of original works some wiggle room between the automatic and complete copyright and the completely open space of the public domain. A Creative Commons license allows authors to selectively choose which rights they want to reserve, which permits other authors to use their work in a larger number of ways, all of which require attribution to the original author.